Hello and welcome everyone to the Polity Primer series of Drishti IAS. My name is Pragya and today we are going to discuss one of the most controversial and contentious issues in the northeastern states, and that is the Armed Forces Special Powers Act, or the AFSPA, which was enacted in the year 1958. In this discussion, we will study about what is AFSPA, or the Armed Forces Special Powers Act. We'll also trace its origin. We are also going to see the declaration of disturbed areas. So this term disturbed areas is a key term here, and we will discuss its definition in our further slides. Then we are also going to see the key issues involved in the this act, Armed Forces Special Powers Act. Then we are also going to see the constitutional validity of this act, that in which case the Honorable Supreme Court has declared this act to be constitutionally valid. Then in the end we are going to see a practice question for your prelims examination and a practice question for your mains examination. So if I talk about the background of our today's discussion, recently this Armed Forces Special Power Act has been reinforced in Manipur, considering the volatile law and order situation there. So a recommendation has been made by the state government on which the central government has reintroduced this act in Manipur. So apart from 19 areas, this act has been enforced all around the Manipur, and many of the areas have been declared to be disturbed areas. So this enforcement of AFSPA in northeastern states often remain in news, and it is one of the contentious issues between the central government and the state government. So what is this AFSPA that I am talking about again and again? What are the powers given to the special forces or the military forces under this act? Let us analyze. So if I talk about the powers that have been given under this act to the armed forces, what do we understand by armed forces here? It includes three things. First is the military forces of the union government. Then there is Air Force. And then there are other forces as well, which are formed under the union government. So if AFSPA is in place in a state, all of these three forces or the armed forces get unsweeping powers. So the extent of powers is very wide. They have unfettered powers to kill anyone acting in contravention of law, and they can also arrest persons without warrant, conduct search without warrant, and they can also apprehend persons under this act. So this act remains very controversial because the human rights activists argue on one point, and that is the immunity from or protection from prosecution and legal suits. So if there is any human right violation done by a person in the armed forces, if AFSPA is in place, then he cannot be prosecuted until and unless the central government grants the sanction. And that is why this act becomes very controversial in nature, and the human rights activists often criticize this provision of AFSPA, that why are they legally protected from prosecution if they are violating the human rights of common citizens. So this is one of the key issues in the AFSPA. And AFSPA gives unfettered powers to the armed forces person. So if I talk about the history or the origin of AFSPA, it was passed by or enacted by the British government. In retaliation to the Quit India Movement Act of 1942. So after independence, our Honorable First Prime Minister of India, Pandit Jawaharlal Nehru, decided to keep this act, to retain this act. And firstly it was an ordinance, and then it became a act, and it was enacted in the year 1958, as I have discussed this before also. So the first law came into effect in 1958 to deal with the uprising in the Nagaland. So if you ask me, ma'am, why do we need this act when we have already criminal provisions like the CRPC or the IPC? So if I talk about the aim or the intent behind enacting this act, so at that time the CRPC and the IPC were not capable of handling cases of insurgency or terrorism. So we enacted this AFSPA as well as the UAPA, UAPA, or the Unlawful Activities Prevention Act. So both of these acts are very strict in nature, and that is why they are also known as draconian laws. So this AFSPA and UAPA were enacted to save the insurgency, to protect the national security. So this was about the enactment of AFSPA. So, and if I talk about the composition of AFSPA, it is composed of two legislation. So there are two legislation. One was enacted in 1958. Its aim was to deal with insurgency, to deal with insurgency and terrorism. In northeastern states. So the first act was enacted in the year 1958, and its main aim was to deal with insurgency and terrorism happening in the northeastern states. Then there was another law which was enacted in 1990 for the state of Jammu and Kashmir. The aim was say to deal with insurgency and terrorist activities happening in the state of Jammu and Kashmir. And both of these legislation combined is known as AFSPA. So this is the composition of AFSPA. It is a combination of two acts. One was enacted in the year 1958 and another was enacted in the year 1990 for the state of Jammu and Kashmir. So if we talk about the origin of AFSPA, the act came into force in the context of increasing violence in the northeastern states decades ago. So this act is very old, as we were saying that it was enacted in the year 1958, which the state governments found it very difficult to control. And that is why the central government stepped in and gave unfettered power to the armed forces to deal with any kind of issue that is going to impact the national security of India. The Armed Forces Special Power Bill was passed by both the houses of parliament and it was approved by the president on September 11, 1958. So, as I was discussing this before also previously, it was a ordinance, then the bill was finally enacted and it became a law when it received the assent of the president. It became to be known as the Armed Forces Special Power Act of 1958. So, this was all about the origin of this act. Now let us understand how are disturbed area declared under this act. What is the definition of disturbed areas on which this act can be applicable? So if I talk about the declaration of the disturbed areas under AFSPA, they are declared under section 3 of this act. And areas are considered disturbed by reason of differences or disputes between members of different religious, racial, language or regional groups or caste or community. So this is a very wide definition that is given, that if there are any differences happening on the basis of religion, caste, community, etc., then that whole area can be declared to be as a disturbed areas. And that is why you can see that the ongoing dispute between the different communities in Manipur, and that is why the state government has recommended the central government to put AFSPA in place in the state of Manipur. Then who has the power to declare these disturbed areas under AFSPA? The governor in the case of the state government and the administrator in the case of the union territory has the power to declare these disturbed areas under section 3 of this act. So this was all about the definition and declaration of the disturbed areas. Now let us study about key issues involved in this act. Why do we criticize this act? Why they have been constant demand of repeal of this act? So the first and the foremost key issue is unlimited power in the hands of armed forces. So as I was discussing in my lecture today, that the AFSPA gives unfettered powers to the armed forces. They can arrest you without warrant. They can search your place without warrant, which is in general cases not allowed. And they can also kill anyone if they feel that they are contravening the law and order situation. So they have this unfettered powers, which is often criticized by the human rights activists. Then there is human rights violation. You might have heard in the news also that the various human rights violation take place when AFSPA is in place. And these human rights violations are done by the people of armed forces to maintain the law and order situation. And as I was explaining this before also, that these human rights violation cannot be called out in court of law until and unless the central government gives its sanction. Then there is license to kill. If the armed forces persons feels that the persons are going against the law and order in that particular state, they can seriously shoot at sight. This is why it is there, it is a key issue that because the activists argue that this definitely gives a license to kill, which is not certainly not allowed in the constitution as well, and not in our criminal provisions, penal provisions as well. You have to prove that murder and it is punishable in nature, but in this case it is not so. They can shoot at sight if they feel that the laws are being contravened. Then there is abuse of power. Definitely power, concentrated power in one hands definitely leads to abuse of power. They abuse their powers and they often contravene the fundamental rights of the citizens. They often forget that they are dealing with their own citizens. So this also happens, and that is why the human rights activists criticize this act. And if I talk about the recommendations of repealing of ASPA, then it was done by three committees. So first is the Jeevan Reddy Commission. Jeevan Reddy Commission. So the first commission to recommend repeal of this act was the Jeevan Reddy Commission. It instead, recommended that this AFSPA should be placed in the UAPA Act. So as per this committee, the provisions of the UAPA Act were sufficient to deal with the cases of terrorism and insurgency. Then came the second ARC report. Second ARC report, which also recommended the repeal of this provision. Then there was a committee constituted by the Supreme Court known as the Santosh Hedge Committee. Santosh Hedge Committee. It recommended that the provisions or the situation of the state in which AFSPA is under place should be reviewed time and again, if after every 6 months. But we can see that what is happening, that it is done on a procedural basis. It is done in a routine manner. And this was opposed by the Santosh Hedge Committee, which clearly laid down that the situation should be assessed after every 6 months, and it should be then decided that whether AFSPA should be continued or it should be removed from that disturbed area, as no disturbances are currently going. But this act is extended as a routine process. So these are the key issues in AFSPA. And if I talk about the constitutional validity of this act or the guidelines of the Supreme Court, then the Supreme Court has upheld the constitutionality of AFSPA in a 1998 judgment, which was titled as Naga People's Movement of Human Rights versus Union of India. In this case, various guidelines were passed by the Supreme Court, such as you cannot use your license to kill until and unless there are definite circumstances. That you cannot abuse your power or abuse the power which is given to you, that is to kill anybody. You have to prove that there was an existence of definite circumstances. And then only you can use this license to kill or the power to kill. Then a suo motu declaration can be made by the central government. However, it is desirable that the state government should be consulted by the central government before making the declaration. So the declaration of AFSPA is done by the central government. In many cases, the state governments recommend the declaration of this act to the central government, but in many cases, the central government bypasses the state government, and that is why it is the Supreme Court held in this case that consultation with the state government is important before declaring AFSPA in a state. Then there were other guidelines which were also given by the Supreme Court in this case. The declaration has to be for a limited duration, and there should be a periodic review of the declaration after every 6 months, and this was reiterated by the Santosh Hedge Committee. That within 6 months you should reassess the situation, and if there is no need, remove the act. But this does not happen. The act is usually extended as a routine basis, as a procedural basis. Then, while exercising the powers conferred upon him by AFSPA, the authorized official should use minimal force necessary for effective action. In fact, the Supreme Court also held that in this case only, that before using such deadly powers, a warning must be issued by the authorized person who is using the powers under AFSPA. And that is why it was important that to stop this abuse of power, it was an important guideline laid down by the Supreme Court. Then the Supreme Court also said that you cannot blatantly misuse your power. You have to use minimum force first. And if then you feel that there is a prima facie need to use more force, then only you should more force. And the Supreme Court in this case also suggested that a high level committee should also review those areas which have been declared as disturbed under AFSPA. So our review by a high level committee of those areas which has been declared as to be disturbed should also be done, so as to protect the areas which do not require the provisions of AFSPA to be put in place. So, to maintain the transparency of this act and to prevent the abuse of powers given under this act, these were the guidelines which were given by the Honorable Supreme Court. So, with this, we come to a conclusion of our today's discussion. We have seen what is AFSPA. We have also analyzed its origin. We have also seen that what are the key issues involved in this act and why are the human rights activists arguing against this act, and we have also seen the constitutional validity of this act. Now let us see a practice question for your prelims examination. So the question is, consider the following statements. So your statement number 1 is, the AFSPA give armed forces personnel operating in disturbed areas sweeping powers. Then your statement number 2 is, the act further says that after any suspects apprehended by security forces should be handed over to the local police station within 24 hours. Which of the following given statement given above are correct? Your options are, option A is 1 only, option 2 is B is 2 only, option C is both 1 and 2, and option D is none of the above. Kindly drop your answers in the comment box below. Now let us analyze a practice question for your mains examination. Critically evaluate the powers given to the armed forces by AFSPA. Is AFSPA against human rights? Comment. So you can begin that what is this act? How was it enacted? You can also say that this act also has a colonial past. It was first enacted by the British government. We retained the act after independence. You will write about the powers of or the license to kill, to arrest without warrant, and you will also mention the immunity from arrest that is given to the personnel who are exercising the powers under this act. You will also write the key issues, that there is abuse of power, there is human rights violation, the fundamental rights are also violated. So you'll talk about all of the key issues which I have discussed in my discussion today. And then you can conclude that definitely the committee's recommendation of reviewing the situation after 6 months should be implemented, and if it is possible, this act should be repealed and the relevant provisions can also be placed under the UAPA Act. I hope this session was insightful for you. If you liked today's discussion, kindly like the video and subscribe to our channel for more such updates. Thank you.